Hey guys, it's Mo with Mo in the Deep End, and we have more Delphi dumpster fire news. Now, the defense has filed another motion, and this is kind of a doozy. Now, this ties back to the defense. If you remember, there were allegations of Richard Allen being treated unfairly and mocked by guards in Westfield Correctional Facility. Now, this information, this whistleblower that's witness came from the inmate population, and the defense was going to call this or had subpoenaed this particular witness to show up for an emergency change of, prison or jail kind of placement for Richard Allen. Well, according to different conflicting reports, either Judge Gull told the deputies that when this particular prison kind of made a kerfuffle about leaving, that he wasn't going to leave his cell, that he didn't have to, he didn't wanna. Judge Gull is alleged to have said, "Just ignore that, let him be there," and didn't tell the defense that she had made this particular decision. Now, according to Judge Gull, she never said this, but was in possession of records that memorialized her behavior. So, erroneous records for very long time didn't release them to the defense. So the defense really had no understanding of how a witness they had subpoenaed was allowed to not show up to court because I guess he just didn't feel like it. So this has been sort of a slow moving issue, but it looks like the defense is taking no prisoners anymore. Now, again, for anyone new to the channel, I am not a lawyer. I am just a layperson who has followed the Delphi case because it's only about 2 hours away from where I currently live. And I do have girls that would be around the same age as Libby and uh, excuse me, and Abby. So this has been a case that I really wanted them to solve, but uh, thus far, what the state has been able to show, prove, and otherwise is very suspect, and a lot of it is not a beat for beat sort of redub of the Karen Reed case, but there is definitely a stiff undercurrent of at least the optics of corruption of the state strong arming a little person who they have very little tangible evidence on. So there are some parallels, and if you would like to look into this case a little bit more, I do have a Delphi list. Um, as a mom of six and, you know, well, somewhat hot mess express of a person, I am not always as up to date with every single filing, but I do try to keep up with the bigger filings, and this is one of them. So let's get into it because it is 21 pages long. Uh, State of Indiana, County of Carroll County, State of Indiana versus Richard Allen. Accused response to this court's May 30th, 2024 order or judgment of the court and notice of conflict. Now comes the accused, Richard Allen, by and through counsel and files his response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. In support of said motion, Mr. Allen states the following introduction. Number one, on May 31st, 2024, this court issued its order of judgment of the court concerning the defense's request to have Judge Gull disqualified. Number two, contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts if needed, and to notify the court that due to new information learned in her order, a conflict has been revealed which caused Judge Gull to become a witness. Number three, defense files this response and notice for purposes of maintaining record and does not wish for this pleading to delay future hearings from taking place, particularly hearings related to the defense's request to transfer Richard Allen out of the Department of Corrections, which is the most urgent pending matters that need to be litigated. Also, the defense's response is intended to provide corrected information to Judge Gull as she continues to self evaluate her obligation to recuse herself from the case. She should believe that bias or appearance of bias exists. Footnote 1. 1. A judge is obligated not to hear or decide matters in which disqualification is required, applied regardless of whether a motion to disqualify is filed. Abney versus State. Uh, so emphasis is added, and that is a case that they are citing to explain that this rule is generally best practices. Judge Gull failed to inform the defense that Carroll County Sheriff's Office fabricated facts in a report filed in her court. Number 4. In his motion to disqualify, Mr. Allen noted that according to a June 14th, 2023 report filed by Carroll County Sheriff's Office, hereinafter CCSO, Judge Gull advised the CCSO that it could ignore a valid defense subpoena for Westfield Correctional Facility inmate Robert Baston and refused to transport him to a June 15th, 2023 hearing on Richard Allen's emergency motion to modify safekeeping order. The defense further alleged in its motion to disqualify that because of Judge Gull's actions, the defense is without a key witness for the hearing. Number 5, it was anticipated that the June 15th, 2023 hearing, Mr. Baston would testify as to the harsh, abusive, and unconstitutional treatment of Richard Allen at Westville Correctional Facility. Number 6, the failure of CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. Number 7. However, in her May 31st, 2024 order, Judge Gull claims that she never advised the CCSO to ignore the subpoena and leave Baston behind. 8. Judge Gull's claim contradicts the CCSO report that this court received on June 20th, 2023. Number 9, the June 14th, 2023 report, which was ordered by the court, stated the following. On June 14th, 2023, I, Special Deputy Wasaki Bryan, while on duty, was conducting a transport from Westville Correctional Facility to Carroll County Jail. Upon my arrival, I was escorted to Baston Robert, I'm not going to give his DOC number, segregation unit to conduct the pickup. After waiting, a corrections officer approached and told me Baston is refusing to come out of his cell and told corrections officer, F you can't make me go. The corrections officer told me they will do a cell extraction to get him to my vehicle. I told corrections officer to stand by, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo. I called Carroll County Jail Commander Lori Sidarsik, who I explained the situation to. Now, John Gallipo, or whatever his name is, he is the warden at Westville Correctional Facility. So she then made a phone call to the chief deputy, Tony Lesenby, who contacted Judge Francis Gull's office to inform them of the situation. Judge Gull's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for 6/15/23. Emphasis is added so it wasn't in bold in the record. I then spoke with Warden Gallipo and asked if he could provide me with a letter stating that Baston refused to come out of his cell and did not want to go. The warden agreed he would. He later advised he would bring me the letter on 6/15/23 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. Number 10, the report was approved by Toby Lesenby, who is a key witness in this case. 11, juxtaposed to the CCSO report is Judge Gull's May 31st, 2024 order, in which she stated, quote, decision by the deputy to leave without the witness was his and not directed by the court. Emphasis added. 12. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. 13. Judge Gull has possessed this report since June 20th, 23. 14. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in this report as it related to her purported involvement in the failure to transport Mr. Bastin to the hearing. Number 15. At the very moment of learning that the CCSO filed a report with fabricated facts concerning Judge Gull, she should have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. 16. Further upon Judge Gull learning of the misrepresentation contained in the report, which undermined the evidence Mr. Allen would be able to present, Judge Gull never reset the hearing so Mr. Allen could present the very evidence Judge Gull said she was lacking when she denied Mr. Allen's emergency motion to vacate safekeeping order. Number 17. Additionally, as the court is aware, Richard Allen has filed 4 Frank's motions, indicating that law enforcement has acted intentionally or in bad faith. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss bias based upon based upon law enforcement's destruction of evidence. One of these motions was heard on March 18th, 2024, with the court denying said motion on April 2nd, 2024. 19. To prevail on a motion to dismiss as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defense to prove that law enforcement acted in bad faith. Pimentel versus State. 20. At the March 18th, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement has acted in bad faith over the course of this case. At the time, this court was aware that law enforcement had fabricated facts contained in the June 14th, 2023 report, thereby acting in bad faith, yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. 21. Even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact is that the defense was not able to include that information on the record for the Court of Appeals should it be necessary. 22. Additionally, had Judge Gull alerted Mr. Allen's attorney of Carroll County Sheriff's fabricated statement in that report, the defense could have used that fabricated statement when pursuing their Frank's motions and motions to dismiss in order to provide additional evidence of intentionally and bad faith on the part of the CCSO. 23. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gull prevented the defense from investigating this fabricated story, including through depositions. 24. Judge Gull should have alerted Mr. Allen's attorneys of CCSO's fabricated facts written in their police report well before March 18th, 2024. Motion to dismiss and her failure to do so provides a rational inference of bias. Judge Gull is now a witness in this matter as to Tony Lesenby's credibility. 25. Given that Judge Gull is the only individual who knows that she did not direct the CCSO office to ignore the subpoena and leave Mr. Bastin at Westfield, despite the contrary assertions in the CCSO report, She has become a witness to Tony Lesenby's truthfulness and to the fact that the information contained in the CCSO report was false. 26. The credibility of a witness is always an issue for a jury, Stanley versus State. 27. If Judge Gull's story is correct and she had a ringside seat to the intentional behavior of CCSO and or the bad faith of CCSO in that it, one, intentionally ignored a valid defense subpoena for a defense witness, and then two, fabricated a story in a police report claiming that a sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. 28. At future hearings and at trial, the defense should have the ability to cross examine Tony Lesenby on these contradictory stories with questions similar to the following. Attorney, so this would be either Bradley Rossi or uh, Andrew Baldwin. Mr. Lesenby, the defense attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of the guards abusing Richard Allen in a variety of ways at Westville, but your office ignored a valid subpoena to bring a witness to a hearing. Isn't that right? Or, attorney, you did not want the judge to hear the testimony that the witness of that witness because it would support the defense's contention that Richard Allen was being abused and should be moved to Cass County Jail closer to both his families and attorneys and away from the abuse. Or, attorney, you wanted Richard Allen to remain in Westfield Prison so that he could continue to be housed far from his attorneys and family while emotionally available or vulnerable to the abuse he was suffering at Westville, sorry. Attorney, worse yet, you then lied in a report claiming that Judge Gull advised you it was okay to leave Baston behind. You lied about that in your report. Attorney, Judge Gull never told you it was okay to ignore a valid defense subpoena, did she? Attorney, I am handing you Exhibit 85, which is June 14th, 2023 report from CCSA, in which you claim that Gull gave you the directive allowing you to ignore the subpoena, etc. 29, because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motions to dismiss, as well as the four Franks notices. It must be able to call Judge Gull to the stand to testify concerning false statements contained in the CCSO's June 14th, 2023 report. Judge Gull's testimony is especially vital concerning the defense's motions to modify the safekeeping order, as well as their Frank's motions and motions to dismiss. Number 30, calling Judge Gull to the stand to testify as to the fabricated fact contained in this report is especially important when the very witness who is the subject of this report, Robert Baston, would have testified about Richard Allen's treatment at Westfield, which directly led to the deterioration of his mental state and false statements concerning his involvement in the crime. 31. The defense plans on issuing subpoenas and calling Judge Gull to stand at future hearings and at trial to testify that she never directed CCSO to ignore a valid subpoena and never advised CCSO to leave Robert Baston behind if Baston, did not want to attend the June 15th, 2024 hearing. 32, Judge Gull should recuse herself from this matter as she is now a witness in the proceedings. Judge Gull's failure to admonish CCSO may cause law enforcement to believe that they can create fabricated stories in this case with no consequences. 33. Despite having the CCSO report since June 20th, 2023, to this day, Judge Gull has failed to admonish the CCSO for filing a report that contains such a flagrant falsehood and which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. Judge 34. Judge Gull's failure to address that fabrication in any fashion, however, provides a basis for states' witnesses to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence and provides a rational inference for bias. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. 35. In its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. 36. On March 7th, 2024, Attorney Rossi alerted Judge Gull about his grave concerns surrounding McLeland and receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March 2024 email response, Judge Gull wrote to the defense counsel, I would encourage you to educate your staff on how to properly file pleadings. 37. Attached is a printout from the Docs Pop filing process of February 26, 2024, ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. 38. It should be noted that upon receiving this February 26, 2024 pleading, court staff could see in bold font, capital letters at the top of the pleading the following ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow proper procedural process in ex parte pleadings. 39. The staff for the defense filed the ex parte documents correctly. The Docs Pop printout shows that the only service contacts listed on this ex parte filing were Bradley Rossi, Andrew Baldwin, not Nicholas McLeland, James Luttrell, or Stacy Diner. Now, or Diener. I do have to look up Stacy Diener because, as we remember, Judge Diner or Diener was the judge that was supposed to take this over before he recused himself. So I will be looking up if there is a link between those two because honestly, I've been out of the Delphi game for a little bit. So lucky that I have my handy dandy, uh, post-it notes, which I didn't invent, but will lie about at my next high school reunion if I ever choose to go. Furthermore, the printout shows that all documents were marked as confidential. In the footnote, in her May 31st, 2024 order, Gull seems to believe that parties can only file ex parte documents through the Odyssey platform. If so, she is incorrect. Parties may also file ex parte documents through the Docs Pop platform, which the defense team staff utilized when they correctly filed the February 26, 2024 ex parte document in the case. Over the course of this case, defense staff has used both Odyssey and DocsPop platforms when e-filing ex parte documents. It is telling that the tutorial Judge Gull sent to the defense details how courtroom staff should process ex parte documents they receive in the Odyssey platform and not the DocsPop platform. Number 40. There is nothing else further. Dang it. No, I want the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly filed the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it's filed using Odyssey or DocsPop platforms. 41. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how to process the document into the system, causing Prosecutor McClelland to have access to the ex parte document. 42. In her May 31st, 2024 order, Judge Gold detailed how she sent the defense a tutorial paper authorized by the JTAC explaining the process. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gull's presumption that this tutorial assisted the defense is inaccurate for three reasons. One, the defense was not errantly filing ex parte documents. Two, the tutorial Judge Gull sent how to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. And three, the defense continued to file ex parte documents in the exact same manner as it had been filing before Judge Gull ever sent the tutorial to the defense, and there were no issues. Footnote 3. In her May 31st, 2024 order, Judge Gull, referring to the email, oh, okay, sorry. Referring to the email, she provided the JTAC tutorial stated, since that communication, defense have had no issues with their staff properly filing ex parte pleadings. This court attempted to give credit to JTAC tutorial for her claim that no ex parte issues occurred after she sent the tutorial to the defense. However, this is simply not true, as the tutorial provided no guidance for practicing lawyers, and as discussed above, the defense had already correctly filed ex parte documents. It seems likely that the actual reason for no further ex parte issues was that the court staff actually learned the proper manner in which to process ex parte documents. For the love of all that is holy. 43. The quote unquote tutorial Judge Gull emailed to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gull refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is just a tutorial for court staff. Please find attached a printout of the quote unquote tutorial Judge Gull sent to the defense, marked as Exhibit B, which also includes the cheat sheet referenced in the letter from the Court of Service, or the Office of Court Services. 44. Even though on its face the tutorial clearly appears directed to assist court staffs in understanding how to process and accept ex parte filings, the defense staff still reviewed the tutorial sent by Judge Gull to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document. It doesn't. When defense staff clicked on the link detailed in step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gull proclaimed in her order as helpful to the defense was actually meant for court staff. I mean, at what point does Indiana just kind of say, "Hey, ma'am, how about you go retire?" Judge Gull has failed to admonish Prosecutor McClelland for improperly reading ex parte pleadings while continued to denigrate defense counsel. 45. The pleadings errantly made accessible to Prosecutor McClelland were clearly marked ex parte. 46. The defense became aware that Prosecutor McClelland read the ex parte documents based on a March 6, 2024 prosecution filing in which the prosecutor directly quoted from a defense ex parte filing from February 26, 2024. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. 47. After reading Prosecutor McClelland's March 6, 2024 filing and realizing that McClelland had reviewed a defense ex parte document, Attorney Rozzi sent an email to Judge Gull and Judge Gull's staff members, as well as to Nick McClelland. Find attached copy of said email marked as Exhibit C. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. 48. Then on March 7th, 2024, Prosecutor McClelland filed a pleading in which McClelland, finally admitted that he also had access to three other ex parte filings. Footnote 4. After reviewing the record, the defense believes that Prosecutor McClelland actually reviewed only two ex parte filings, as two of the filings he referenced in this pleading he identified as ex parte were not ex parte filings. Does anyone know how to lawful law around this courthouse? I mean, except for the defense attorneys? 49. Despite clear markings of ex parte on documents, Prosecutor McClelland chose to read those ex parte documents rather than promptly deleting them and alerting the defense of misdirected filing as required under Indiana Rule of Professional Conduct, IRPC 4.4, subsection B. A lawyer who receives a document relating to the representation of a lawyer's client and knows or reasonably knows that the document was inadvertently sent shall promptly notify the sender. I mean, considering Judge Gull got big, mad, and hateful that, one of the defense's emails populated the wrong Bradley, I think, it's a bit rich. Number 50. Prosecutor McClelland never contacted defense counsel after receiving the ex parte documents as required under IRPC 4.4 subclause B. The defense only learned of this violation upon reviewing McClelland's March 6, 2024 pleading, in which McClelland audaciously quoted directly from the ex parte document, making that quote available for public view. 51. The act of McClelland reading from the defense's ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of a subversion of Richard Allen's due process rights. 52. This court has failed to reprimand the prosecution for reading ex parte documents or to even address that issue in any way whatsoever. Nor has Judge Gull filed a pleading in which Judge Gull, publicly proclaimed she was referring Nick McClelland to the Office of Judicial and Attorney Regulation Executive Director Adrian Meering for that office to reinforce rules or determine the counsel's ethical misconduct. Footnote 5. This is a quote taken directly from Judge Gull's April 30th, 2024 order of judgment of the court concerning the prosecution's request that the defense counsel be found in contempt. 53. This court has publicly declared in its April 30th, 2024 order that it was referring to defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press relief that the defense counsel set out to media sources when no gag order was in place after prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on a much more serious allegation of McClelland reviewing ex parte documents and violating IRPC 4.4 subsection B, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently than the defense counsel, and this provides a rational inference of bias. This court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rossi. 54. In her May 30th, 2024 order denying the defense's request for disqualification, this court maintained that it has no bias against defense counsel. I mean, it kind of looks like bias to me, but maybe I mean, these are fake glasses, so maybe I just can't see it. Uh, Ma'am, come on now. You have been biased as all Hades against these two. 55. On January 22nd, 2024, this court denied Baldwin and Rousey's request for a Franks hearing. At that point in time, this court had failed to rule on the Franks' request for over 4 months. Yet, within 4 days of their re entering the appearance on this case, Judge Gull denied their request without a hearing. 56. However, after Baldwin and Rossi were taken off the case in October 2023, Judge Gull informed her newly handpicked public defenders that they should review the prior counsel's pleadings and either adopt those pleadings or make them their own. In November 20 or I'm sorry, 14th, 2023, CCS entry, it was memorialized that Judge Gull informed the new public defenders, Scremin and Labrado, that, quote, if defendants' new counsels informed the court they intend to pursue the Franks motion, the court will schedule a hearing, emphasis added. 57. Such action demonstrates this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rossi, in that after they were re entered in their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. 58. This disparate treatment of attorneys Baldwin and Rossi compared to this court's treatment of the prosecution, even of the replacement public defenders, provides a rational inference of bias against defense counsel Baldwin and Rossi and therefore against Allen. In this order, the court claimed that it is irrational and unreasonable for the defense to assert that as lawyers with 70 years of combined experience, they have never had a judge provide a hard end trial date or hard end date for a trial. Calling the defense counsel irrational and unreasonable shows bias, especially when the court is wrong in its understanding of jury rule number 4. This court unfortunately continues to malign defense counsel by calling them irrational and unreasonable for their averments that courts around the state law Indiana never set a rigid day for a trial to end. Implicitly, the court is also averring the defense counsel uh, are lying about their experience in courts around the state of Indiana. Furthermore, the court maligns defense counsel concerning its knowledge of jury rules, when it is the court that is incorrect in the assessment of jury rules. 60. At the May 7th, 2024 pretrial hearing, the court stated, quote, well, you understand. Well, maybe you don't understand. Jury Rule 4 requires I issue summonses to a jury which states the date of the trial. Jury Rule 4 requires that I issue summons to juries with the dates. Transcript, May 7th, 2024, hearing, page 12, line 13, emphasis added. 61. The court cited Jury Rule 4 as a basis for limiting the time of the trial. However, Jury Rule 4 has not ever discussed the length or dates of trial required courts to place a hard end date for a trial. Jury Rule 4 states that, quote, not later than 7 days after the date of drawing names from a jury pool, the jury administrator shall mail each person whose name is drawn a juror qualification form and a notice of the period during which any service may be performed, end quote. 62. Jury Rule 4 is primarily referencing a time span or term during which citizens, sorry, need to be on alert that they could be summoned for jury duty, IG, when they are on call for possible jury duty. Prospective jurors needs to be aware that over the course of a specified number of months, the court may summons them to appear in court as a potential juror at a later date. 63, Jury Rule 4 further states that when summoning a prospective juror in a jury duty, that, quote, the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, i.e., cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the Americans with Disabilities Act. End quote. 64. Note that Jury Rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does Jury Rule 4 requires prospective juror to be advised of the beginning or end date of a trial. Jury Rule 9, term of jury service states, quote, a person who appears for service as a predit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of trial. Excuse me. Or the manner in which the trial is disposed, end quote. Once 66, once summoned in and selected as a juror, Juror Rule 9 is a juror rule that comes closest to referring to the length of the actual trial. 67, note that Jury Rule 9 places no limit to the actual trial once a juror is selected, nor does Jury Rule 9 place on a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials with varying lengths. Footnote 6. In Marion County, for example, prospective jurors arrive, gather in a large room, not knowing which court or what trial they may be called upon to serve on, as often multiple jury trials are conducted at the same time on the same day. The prospective juror could be asked to serve any one of those trials. 68. In spite of Judge Gull's proclamation at the May 7th, 2024 hearing, Indiana jury rules do not provide or require a mechanism built uh, to limit the length of a trial whatsoever, including as it relates to information contained in the jury summons that the court sends out to citizens pursuing uh, Jury Rule number 4. 69. Judge Gull's errant interpretation of Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure himself a trial where he could thoroughly present his defense without time restrictions. 70. Judge Gull's bungling of Mr. Allen's speedy trial right due to her misunderstanding of what the jury rules require in the summons not only negatively affected the defendant and his constitutional rights, not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. 71. Additionally, at May 7th, 2024 hearing, Judge Gull cited several cases over which she has presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of the trial is determined by the number of witnesses, the amount of evidence, and the length of investigation and complexity of issues involved. 72. This is the case of the state of Indiana versus Richard Allen, with his own sets of facts, challenges, and potential pitfalls that could cause a trial to last beyond what the parties expect. For example, several witnesses reside over 125 plus miles away. If any of those witnesses fails to appear in spite of being properly subpoenaed, the trial may be delayed while parties try to determine how to deal with a witness whose car may have broken down or may have simply ignored a valid subpoena. These situations arise in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. Additionally, of the approximate 185 witnesses identified by the party, a dozen or more are expert witnesses whose testimony will generally take longer and will be more complex than fact witnesses. 74 for this court to call the defense counsel irrational and unreasonable for stating the truth that they have never had a judge s- set a hard end date to a trial provides a rational inference of bias against the defense. Additionally, it's shocking and disconcerting that the court has refuted or refused to place a time limit on the time allotted to the prosecution, but absolutely limited the time for trial, thereby limiting Mr. Allen's time to present his defense. Under 76, under the court's order, the trial was to last from approximately May 13th, 2024 through May 31st, 2024, thereby allowing approximately 13 days for the opening statement, testimony, evidence, rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would leave only 5 days for Mr. Allen to present his witnesses, which include at least five expert witnesses, without even factoring in rebuttal evidence, surrebuttal evidence, arguing final instructions, and closing arguments. 77. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process of witnesses, and his 14th Amendment right uh, of due process to present a defense. 78. In the context of its request for Judge Gull to disqualify herself, this court's maligning of defense counsel as irrational and unreasonable, when in fact it was the court that was wrong in its understanding of jury rules and also wrong in its claim that the courts statewide provide a hard end date to trials, offers a rational inference of basis against the defense. You don't say. Judge Gull's May 31st, 2024 explanation of her denial for defense motions without a hearing provides a rational inference of bias. 79 in its May 31st, 2024 order, when explaining why the court had denied several defense motions without a hearing, the court stated, if pleadings on their face are not supported by law or admissible evidence, judicial economy does not require a hearing. 80. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how this court could determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence subject to possible objection by the prosecution. 81. Judge Gull's claim that the defense evidence is inadmissible before conducting a hearing, before listening to the defendant's contextualization of the evidence surrounding their legal arguments, provides a rational inference for bias against the defense. 82. This court's denial of defense motions without a hearing based on reasons this court cites in its May 31, 2024 order establishes this court's prevailing defense evidence as inadmissible, or I'm sorry, prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleadings before this court even hears any evidence is additional proof that this court is prejudging evidence. This court denying the defense's request to contained in its pleading without a hearing based on her prejudging evidence provides a rational inference of bias. 83. In future, this court denies defense motions based on the court's belief that the defense pleading is, quote, not supported by the law or admissible evidence. The defense then requests the court to identify the evidence cited in the defense pleading that this court believes is inadmissible, then explain why the court believes this evidence is inadmissible. Also, instead of stating denied without hearing, defense will request the court to explain why a pleading is not supported by law. End quote. Even concerning something as basic as a request for recess, Judge Gull shows favoritism to the prosecution. 84. In her May 31st, 2024 order, Judge Gull expressed that she did not show favoritism to the prosecution. However, Judge Gull has shown her differential treatment between the prosecution and defense in a variety of ways, and some are easily identified, some are less perceptible. 85. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gull's angry tone when addressing defense versus how she speaks to the prosecution, and also visualize the court's disdainful facial expressions she makes towards the defense versus the prosecution. Footnote. To be fair, she always kind of looks like an angry cow to me. 7. In future, the defense will likely request cameras in the courtroom for all hearings and trials for the purposes of transparency to better preserve the record. 86. Although it may seem petty or trivial to the court, the defense offers as an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. 87. At the June 15th, 2023 hearing, Prosecutor McClelland requested a recess, after the following transpired. McClelland, Judge, I have two witnesses. Could I ask the court for a short recess so I could use the restroom? Judge Gull, would counsel approach? Sidebar conference conducted. Judge Gull, I just want to know where we're at. You've got two witnesses? McClelland, Tony Leggett and the Westfield warden. Judge Gull, okay, do you want a break for lunch? Rossi, I don't, but I'm Judge Gull, okay. McClelland, so I don't care, I can. Inaudible. Judge Gull, yeah, we could take a quick break. How long? McClelland, I don't mean to be a pain, but Judge Gull, no, that's all right. How long do you think you'll be? McClelland, downstairs and right back up. Judge Gull, no, I mean your witnesses with your evidence. McClelland, oh. Judge Gull, ding dong, I don't care how long it takes you to go there. No, I don't care about that. McClelland, I don't really think too long. Inaudible. Tony about the transportation resources and the warden just to address allegations they made in their safekeeping. Judge Gull, so like an hour and a half? McClelland, I guess I just couldn't. Judge Gull, let's break for lunch. I don't want you to. Uh, I I know you don't want to, but too bad. Rossi, I'm fine with whatever. Judge Gull, okay, let's just break for lunch. Rossi, I don't have anywhere I need to be. Judge Gull, well, I know you don't because you were supposed to be here for 2 days. 88. However, at the May 7th, 2024 hearing, the court treated the defense much differently when the defense sought a short recess to confer with their client on urgent matters concerning the positives and negatives of continuing Mr. Allen's speedy trial due to Judge Gull's hard end date of May 31st, 2024, following a back and forth exchange between Judge Gull and defense counsel concerning the defense's need for more time for trial than Judge Gull was allowed. This occurred. Rossi, can we have a 5-minute recess? Judge Gull, why? Rossi, I would like to speak with my co-counsel here and have a discussion about business issues such as scheduling, not here in the courtroom where everyone is listening to us. We've got, 50 staff members in this courtroom, people sitting behind. There's no privacy. I'd like to talk to him in the hallway about some logistics of this so we can properly solve this problem so he and Mr. Allen can put on a defense. Judge Gull, does the state of Indiana have any objection to the recess? McClelland, no, Your Honor. Judge Gull, all right, Jody, you can go off record. 89. Judge Gull did not respond playfully with Brad Razi ding dong, but instead questioned Razi's reasons for seeking a recess. Then Judge Gull surprisingly asked the prosecutor if he, the prosecutor, had an objection about seeking a 5-minute recess so the defense counsel could talk to their client about important matters concerning seeking a continuance of a speedy trial due to the court's unwillingness to provide more time to the defense at trial. 90. When a defense attorney requests a 5-minute recess to talk to their client on such weighty matters as constitutional rights related to continuing a speedy trial, it should be met with a simple of course and not require approval of the prosecutor. 91. The fact that Judge Gull treats defense differently on such a basic matter as requests for a recess provides a rational basis for a rational inference of bias. This court has failed to address the appearance of bias, which exists in spades, in my opinion, in this case. 92. Judge Gull claims in her order as counsel should know criminal cases are tied in a court of law are tried in a court of law and not a court of public opinion. 93. However, the standard for recusal is not just whether actual bias exists, but the whether also the appearance of bias exists. Footnote 8. The mere appearance of bias and partiality may require recusal if an objective person knowledgeable of all circumstances would have a rational basis for doubting the judge's partiality. Bloomington Magazine v. Klang. So, even if you appear to be all of the Judgy McThundercow, you should probably not. The judge must consider both actual bias and the appearance of bias when determining whether to disqualify herself. 94. Judge Gull appears to conflate the general concept. On occasion, the public will vehemently criticize a judge with defense's specific contention that many in public are particularly criticizing for her for what the public perceives as actual bias against the defense. Footnote 9. As part of the legal reasoning obtained in her order, Judge Gull cites being threatened with bodily harm and injury. She is not alone, as defense counsel is also receiving death threats and threats of bodily harm. Regardless, the defense sees no linkage between the appearance of bias existing and Judge Gull's mentioning that she or any party has been threatened. And it, regardless of where you stand on this, I don't want people getting death threats or unaliving. I think she's a terrible judge. I think should recuse herself from this trial, but I don't want harm upon her or anyone else that's involved in this trial. Let's see here. 20 or 95, the emails which defense attached to the motion, the memes the defense referenced in the motion detail how the public believes that Judge Gull is biased against the defense. 96, the defense agrees with court that general complaints by the public are concerning the court rulings should not cause her to disqualify herself. 10, it's it is true that many in the public have written both Judge Gull and the Indiana Supreme Court to complain that the judge is wrong in various rulings, particularly whether the judge should allow courtrooms or cameras in the courtroom. However, these complaints would not support an appearance of bias. However, this is not what the defense is discussing in the motion. 97. The defense believes actual bias exists. It is the appearance of bias against the defense about which the public has complained. It is the appearance of bias against the defense about which the public has written the Supreme Court. It is the appearance of bias against the defense about which the public has written Judge Gull, and it is the appearance of bias against the defense, the existence of which Judge Gull should recognize and for which Judge Gull should voluntarily recuse herself. Failure to address other issues contained in the first motion to disqualify. 98. The court addressed a few other defense issues contained in their second motion to have Judge Gull disqualify herself. The defense stands by those reasons as well and does not waive those issues for purposes of appeal. 99. However, in the May 31st order, this court failed to address all issues contained in the defense's first motion to have Judge Gull disqualified, which the defense incorporated into its second motion. 100. The defense requests that Judge Gull to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based on the itemized reasons contained in those motions, as well as in this response. Conclusion 101. The defense wishes to move forward and have this court conduct hearings, most immediately the request to have Richard Allen moved from the DOC to either Cass or Tippecanoe County jails while awaiting trial. And 102, this motion is intended to respond to Judge Gull's order for purposes of preserving the issues for the record, and so that Judge Gull may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation whether or not the defense is seeking her recusal. Wherefore, the defense files its response to Judge Gull's May 31st, 2024, quote, order or judgment of the court concerning her denial of the defense request for disqualification. So that was a long one, you guys. I didn't expect it to be that long, but um, it is deeply disturbing to have 101 detailed items where the judge is looking exceptionally shady. So, unfortunately, I think this changes nothing. I hope that this preserves things on appeal, but it seems like the judge is willfully and, if not maliciously, then with purpose making these rulings against the defense. But that's what I have for you today. Thank you for joining. I know this was a long video, but definitely, this is one of the bigger notices, and again, goes to outline real cases and sources of even optically just having a bias against the defense. Thanks for joining. If you like this video, please, press the thumbs up, share with your friends if they want to get in on the Delphi madness, and I will see you guys in a little bit. Bye, guys.